This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Welcome everybody. I am Leonard French, your favorite copyright attorney, and we're here to discuss another egregious overreach by the mouse by Disney. You've seen Disney do something. Disney is responsible for the length of the copyright protection term these days, life of the author plus 70 years. I think it was the Sonny Bono Copyright Extension Act or something that was very much coming from Disney, or Disney put a lot of effort into it. I'm sure it wasn't entirely Disney, but it was major media creators that were behind that. Disney was among one of them. This is a tweet that Disney put out today. Celebrate the saga. Reply with your favorite hashtag Star Wars memory, and you may see it somewhere special on hashtag May the 4th. By sharing your message with us using hashtag May the 4th, you agree to our use of the message and your account name in all media and our terms of use here at DisneyTermsOfUse.com. And then they did clarify, I guess, sometime later, because this was 10 hours ago for me, so 10 a.m. Then this one was also 10 a.m. And then 5 hours later at 3:07, they say the above legal language applies only to replies to this tweet using hashtag May the 4th and mentioning Disney Plus. So you had to hashtag May the 4th and mention Disney Plus. These replies may appear in something special on May the 4th. Well, I don't know that actually has any legal effect, and I wanted to take this opportunity to go over that with you, that I don't think they can just do this. I don't think this is something that just works. Now, I do want to go over sort of the practical reality of it, forgetting for a moment that there's legal ramifications and contract formation and all sorts of laws that more or less say that this doesn't work. And there's also a contract with Twitter. Remember, you're on Twitter, not on Disney. But practical considerations, what are they actually doing here? They want you to share your Star Wars memories using hashtag May the 4th, and they want you to tag Disney Plus, and then Disney is going to either embed your tweet, which we recently saw a case, an Instagram embedding, where if you use the service's embedding API, application programming interface, then there's no legal problem there, and you can worry about, or you can not worry. You can be clear from being successfully sued for embedding a tweet. But they say here they want your account name in all media. So all media would also mean that maybe they're going to put it on Disney Plus. Maybe they're going to put it on their website. Maybe it's not going to be an embed. Maybe it's going to be a screenshot. Maybe it's going to be in a video. Maybe it's going to be on advertising. Maybe they're going to print it on postcards or something and hand it out at, well, I guess Disneyland is actually closed right now. So, but maybe they're going to do more than just electronically embed it using the existing Twitter API, which is about the only way that I could think this would be completely legal. So I thought, let's have a hangout, guys, and let's talk about what in the world could be going on here, like legally, if anything at all. So I thought maybe we could start with some basics of contracts and what a shrink wrap, click wrap, and browse wrap agreements are. So Disney, by making this tweet, they are trying to establish some sort of relationship with a user who is going to interact with the May the 4th hashtag. Of course, if you have been living under a rock and you don't know what in the world we're talking about with May the 4th, why is May the 4th so important? Would anyone like to tell us why May the 4th is important? It's become kind of the annual Star Wars day. Seriously, everybody knows what I'm talking about here, so I'm not even sure I have to say this, but let's just pretend that there are people out there who might not know. Disney has bought Star Wars. Star Wars used to be Lucasfilm, right? George Lucas and Lucasfilm. Disney bought Star Wars, and actually probably since before Disney bought Star Wars, people have been saying, "May the Force be with you," or on the month of May's fourth day, they say, "May the Fourth be with you." And it's like funny. It's like may the Fourth be with you. May the Fourth be with you. So May the 4th has become basically the official Star Wars Day. And so of course Disney wants to celebrate Star Wars Day on May the 4th with everybody and have a good time. But by trying to write language like this, you agree. By using this hashtag, you agree to our use of the message. They're trying to establish some kind of relationship with you. What kind of thing do we call a legal relationship between parties? That's a contract, right? There's also like negligence. There's also like duty, injury, breach, and cause. This isn't that. They're not asking for you to incur a duty or anything. They're instead modifying the legal relationship between you and Disney Plus, and that's a contract. So this tweet is an attempt to create a contract. We need some things in order to have formed a contract. And some of those things are like mutual assent. The parties meant to form a contract. A meeting of the minds. The parties both knew what the contract involved. They knew the terms of the contract. They meant to agree to the terms of the contract. So is there a meeting of the minds here? Has Disney discussed the contract with you, come to a series of terms? Well, they're attempting to do that. They're attempting to say that if you do these actions of using the May the 4th hashtag and tagging Disney Plus, which I guess they clarified that, but that wasn't part of the original tweet. But they have created a whole contract at the Disney Terms of Use website here. So they have a whole series of contract terms here. We'll go to the first one. These terms are a contract between you and Disney, a Delaware limited liability company. You represent to Disney that you have read these, etc. So yeah, they really want this to bind you to the Disney Plus terms of use. Is this actually just the Disney Plus terms of use, or is this all of Disney? It's all of Disney. It's the Disney terms of use. So let's see here. Pleased to provide you with certain websites, software applications, etc. But really, did they provide you with Twitter? They didn't provide you with Twitter. They provided you with Disney and Disney Plus. So that's interesting. So could there really be a set of parties that could reach a mutual assent or a mutual agreement? Yeah, I guess that would be possible if a party was willing, if a party was saying, oh, yeah, I totally agree to this. Let me use the May the 4th hashtag and tweet at Disney Plus, and I'll share my Star Wars memory because I want Disney to use my tweet. Okay, so I guess it's possible that if a person wanted to be bound by this, they could consider themselves to be bound. And how's that going to play out anyway? A person who's considered themselves to be bound is just, not going to take issue with Disney using their tweet in an all media and account name way outside of Twitter, I guess. So if Leonard French tweeted at Disney Plus and hashtag May the 4th, and I shared a Star Wars memory and Disney liked it, they could go use it, and Leonard French would probably not do anything about it because either I don't care or I have actually assented to these terms. But what if you didn't want to assent to these terms? Are you suddenly now bound by these terms because you used a hashtag May the 4th and added Disney Plus? What if I want to tweet at Disney Plus saying that I disagree with their use of the hashtag May the 4th? Can they then use that tweet? Well, that's what they're trying to say, and I don't think they can actually do that. They have tried to limit it here with the whole only tweets that are replying to this thread. So only if you reply to the thread. I still think that that's meaningless. The parties have to have a meeting of the minds and basically sign the contract in some way. So can the parties, upon seeing this, actually sign the contract in some way? So have a meeting of the minds. They both meant to us to agree to a contract. How can you sign a tweet? Well, you can't. But we have a kind of contract called a shrink wrap agreement. A different kind that's similar but different is a click wrap agreement, and similar but different is a browse wrap agreement. Now, click wrap and browse wrap, those are made up words. Shrink wrap is really where it came from. Shrink wrap agreements are from the days when you used to buy software in a store. And you would go to the store and they would literally have software in boxes. I know this is amusing to some people. They'd have software in boxes on floppy disks or on compact discs, CDs, or on DVDs. I guess you can still buy software on Blu-rays. I guess the most modern version of this is console games, where you buy a disc on Blu-ray or whatever Xbox is using these days. I think it's Blu-ray. And when you open the shrink wrap, then you have agreed to something. Well, not really. That's not how it's done these days. In the past, what would happen is there was actually a little sticker on the shrink wrap that said, by breaking this shrink wrap, you agree to the software license inside. If you don't agree to the software license inside, then you have to return the thing somehow. I haven't heard of too many people actually returning the thing, but I have heard that it's possible, even if the store doesn't have a policy of accepting returns once the shrink wrap is broken. But modern times, I believe they say on the back of the disc or something, on the back of the box, by opening this, you agree to the terms of service. That's what we would call a shrink wrap agreement. And courts have said that you can have a shrink wrap agreement provided that the agreement notice is valid, notifies the user that they're buying software that's subject to terms of service and that you need to agree to the terms of service before you can use the thing. Many times when you do a software shrink wrap agreement, there will be another place to agree to it with an accept button, which would be what we would call a click wrap agreement. We recently studied this with the Redbox case, where Redbox and their terms of service, their terms of service were found to be non-binding on one particular user who said that they never actually assented to the terms of service. And the judge agreed, and the judge had seen that the click to accept was actually way separate on the screen from a place where it said, by clicking you accept. Instead, it was by clicking pay online, you accept our agreement. But it was like 3 further buttons removed from the pay online button. Those buttons had nothing to do with payment. They were about rewards and FAQs or something. And so the click wrap agreement failed in that case. So do we have a shrink wrap agreement? Are you buying something and opening it and finding out that it is subject to terms? No. Is this a click wrap agreement? Are you clicking on terms of service or something that says I have read and agree to the terms of service? No. So what we've got left then is what I would call a browse wrap agreement. This is where when you browse a website, there will be language, usually on the bottom of the page, that says, by using this website, you agree to our terms of service and privacy policy. And those are valid only when they are both temporally and spatially proximate to your browsing. So in other words, if I'm on a website that I don't have to log into, and I don't have to physically agree to their terms of service via a click or something. If I'm just using a website, I don't know, I can't think of one off the top of my head, but maybe Reddit is like this or something. By using the website, do you agree to the terms of service automatically? No. The website has to notify you in some way, and maybe you can see the theme here of notice. They have to tell you that you're being bound by an agreement. But Leonard, yes, they told us. Yes, we'll get to that in a moment. So a browse wrap agreement if you browse to a website and it pops up something that says, by continuing to browse this website, you agree to our terms of service. Okay, that might work. If you're going that far, you might as well make a click wrap agreement anyway, because it's more powerful agreement. But a browse wrap agreement could become binding on a person who used a website, who had a notice about the agreement that was spatially and temporally time connected to the browsing. So in other words, if you had to see it and you had to be able to make the connection that it was regarding browsing and all that, then yeah, you could be bound by a browse wrap agreement. Is this a browse wrap agreement? Well, I think it's an attempt at one. I think they're trying to say that if you read these words on our Twitter account, then you are bound by these words. I still don't think that that's true. Because think about this for a moment. We are on Twitter. You are already using Twitter within the terms of service that Twitter makes you agree to when you sign up to an account. And I'm not going to sign up, but I bet that if I signed up to Twitter now and created an account, I bet you somewhere in here it's going to say you agree to Twitter terms of service. Let's just, I don't know, this isn't going to work, but we're going to try it. Yeah, they don't like my phone number. They really don't like my phone number. Let's use the school's phone number. You don't like the school's phone number? They really don't like the school's phone number. Jeez. Okay. Well, we're just going to call that. We're going to call that a failed experiment. Of course, now I can't even back out. There we go. We're just going to call that a failed experiment. But I expect somewhere in there, Disney. I expect somewhere on Twitter's sign-up page, Disney will ask you for an agreement. No, I suspect that somewhere during Twitter's sign-up process, they will ask you to agree, and that would be considered a click wrap agreement. Well, you agree to Twitter's terms of service, not Disney's, and there's been legal precedent or legal findings or court opinions. I'm very articulate tonight. Court opinions that when you're using something within the bounds of your contract, it's not a violation of the contract or something to do so. In other words, if you have the discretion to use Twitter the way Twitter's supposed to be used, you're not violating Twitter's agreement. And I don't really see how you could be bound by somebody else's agreement when you're using a different company's service. So you're using Twitter's service. How can they use Twitter to bind you to Disney's terms of service? Again, I can think of a different scenario where, like, if I was in someone's direct messages, or if I was publicly messaging with someone, I could probably come up with language that would actually make a contract. But this is saying more that by browsing Twitter's service and browsing Disney's account, that you have bound yourself to some kind of contract here. So I think this is basically some kind of interference with your contract with Twitter by trying to make you agree to a Disney Plus contract or the Disney Plus terms of use or the Disney terms of use by browsing. I think that they're interfering with your relationship with Twitter. And so technically this is a claim that Twitter could bring against Disney, is some kind of interference with a contract. So then there's other things. In contract law, you can't have an empty contract. In other words, if I make an agreement with you to buy your cow, and you agree to pay me, or I agree to pay you nothing for the cow, that's not a contract all by itself. You might have a situation where I might need the cow and I might build a stall for the cow. I might build a barn and a stall and all that, and then you don't give me the cow, and maybe I've relied on your promise to give me the cow. That's different. That's a remedy that's sort of under contract law. It's like a contract. It's called detrimental reliance. I've relied on your promise to my detriment, but that's not a contract. A contract requires what we call consideration, which is the thing, the bargain, the thing you're giving and receiving. What is Disney giving you? So you're agreeing to things, you're agreeing to be bound by the Disney terms of service here. What is Disney giving you in return? It doesn't have to be much. Courts have said that it can be as little as a mere peppercorn, was an actual phrase asserted by a court. I think it was a Supreme Court. I might be wrong about whether that's a Supreme Court case, but judges have said that a mere peppercorn, in other words, a little, pepper, you grind pepper out of peppercorns. So just a little, meaningless peppercorn that, just a spice, a simple spice, a kernel of a spice is really all that you need for contract. If I say, I'll buy your cow for a crumb of peppercorn, for a mere peppercorn, that would be a valid contract and a court would have to uphold it. But where is that consideration here in this tweet? Where? What is Disney giving you? Disney is not agreeing to share your tweet. Disney is saying that you are granting them the rights to your tweet, at least a non-exclusive right or license to use your account name in all media and to use the message, of course. So what is Disney giving you? Exposure, as in like, we're going to put your tweet up on Disney Plus, is not what's being offered here. They're saying they could put your tweet up on Disney Plus, and maybe you are giving them some sort of implied license so that they're clear, but I don't actually see anything in here that would be considered consideration. By sharing your message with us using the Twitter features of hashtags and tagging a user's account with an @ mark, those are Twitter features, so Disney's not giving those to you. You agree to our use of the message and your account name in all media and our terms of use. So you're actually agreeing to a lot in consideration for nothing, or maybe the opportunity to have your tweet shared with the Disney Plus community. That is very light. That might actually be smaller than a mere peppercorn. Now, how does this actually play out? Like, really, what is really going to come of this? I doubt anything is going to come of this other than a fun story, because I don't actually expect that someone is going to tweet at Disney Plus, hashtag May the 4th, share a Star Wars memory. Disney's going to put it on Disney Plus via a Twitter feature violating means of a screenshot or something. And what? Someone's going to sue Disney. Someone's going to issue a DMCA takedown for Disney's use of the tweet. I don't see it. Why would someone who shares a Star Wars memory and hashtag May the 4th and tags Disney Plus, why would they then issue a takedown? I don't think that will actually happen. I think this is just this is a lawyer who thinks, well, we should cover our butts and maybe give ourselves one more argument. If we go ahead and use your May the 4th tweet and you didn't like it, at least we can go to the judge and say, but we posted this. And then what if Disney interviews you in a deposition and your testimony in a deposition is that you saw this tweet, and whether you agreed to it or not would be in contention, but at least they could say to the judge, we gave them notice that we were going to use it. So I think it's still a legal issue for them, if Disney did find themselves in that situation, I bet you they'd have to backpedal. They'd have to remove the offending tweet or retweet, or I guess it wouldn't be a retweet, it would be a copy. They would remove the infringing tweet. There we go. They'd remove the infringing copy, and the judge would likely have to find some kind of damage. Now, there's another practical consideration here. First of all, is there really any damage? Sort of lost my train of thought. If so, that we have notice, and if they gave notice and you didn't agree. Oh, damages. They don't. How many people register their copyrights in a tweet? So who's going to be able to? You could still issue a DMCA takedown, but you can't issue a lawsuit. How many people actually? I don't know of any. I'd love to hear about the first one, or how many people actually would register a copyright in their tweets. So then you wouldn't be able to sue Disney over this for anything but actual damages. What are the actual damages for Disney having used your tweet? Should they have paid you a license fee to use your tweet? Maybe. Are you in the business of licensing your tweets? I doubt it. Maybe if they used a tweet from another brand account or from a quote-unquote influencer's account who does license their tweets or license the use of their things, they could find themselves in some kind of hot water. But the copyright owner would have to have registered their copyright with the Copyright Office for about $35 or $45, I think it is. And I don't see that you're going to do that. I don't see that people are actually going to register their tweet with the Copyright Office, and then when Disney uses it, they're going to come after them for statutory damages of a minimum of $750 plus attorney's fees and costs. So you're going to be going after Disney with Disney's budget, having not registered your copyright, which is only going to get you actual damages and no attorney's fees and costs. So I don't really see you going after Disney for this. And I don't really see anybody actually taking legal action. So that's an interesting one. So I find this to be absolutely fascinating that Disney would try to make an agreement and bind you to their terms of use, an agreement to clear or release your copyright in a non-exclusive license to your Twitter message and account name. Clarifying here, only replies to the tweet, to the one particular thread of tweets where you tag Disney Plus and use the May the 4th hashtag. And then those replies could appear someplace special, and you've given them license to use your tweet. I think it's an attempt to cover their butts for the way they want to use the tweets. I don't think that this is within the Twitter terms of service, so Twitter could also get involved, but I doubt Twitter is really going to admonish Disney Plus when I'm sure Disney Plus is a valuable partner or a valuable user to have on the Twitter platform. How about if Newegg took Disney to court, they used May the 4th before them? We're not really talking about it being used as a trademark. Using the May the 4th hashtag is probably not a trademark violation unless you used it in a very specific way, trying to sell your products, and the brand would have to have May the 4th, or the branding or source identifying use of the thing, or the use of the thing would have to be source identifying. And I don't see that. Like, it would have to say something like, buy this new action figure from your favorite May the 4th company or something. And then it would have to be not a genuine product from Disney or Star Wars or Lucasfilm. So I don't think that trademark really comes into it too much. So what do you think of that? That's all I have for you today. that's an interesting discussion. I'll leave it up on the screen for you just so you can ponder it some more. I find it to be really really interesting enough to figure out what's going on and take a moment to make a video for you. So anyway, oh, Matt says this is what we call a Mickey Mouse agreement. Yeah. This is Mickey Mouse level stuff here, guys. This is definitely Mickey Mouse level stuff. So that's what I have for you today. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program on YouTube. Thank you to our patreon.com/LJFrench supporters and sponsors.com/law supporters. We also have YouTube memberships and Floatplane subscriptions available, and a Teespring store, which should be below in the description area. Thank you to our $50 plus supporters in the month of April. Thank you to Wes Delj, Video Quarantined, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Michael Pearce, Jan Negrey, Daniel Perez, Aspernari, Joe Tyson, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Nicely Done Defense, Mullen PC, Sean McNamara, Josh Baker, Ugly Grill, Gregory, Shielo T, Michael Moore, and Beastman. Wow, that list is getting long. And thank you to the $5 plus supporters who are scrolling on the LED panel next to me. I'll leave it there. Hope you guys have a good one. Love you all. I'll see you in the videos that drop.